Do we know who admin is?
Elaine, is that the victim's family? Yes, I believe that is,
Okay.
Judge.
When I saying I was opening the wrong app here. I need my email to get, Mr. Liker, you sent me a new plea petition, correct?
Yeah, there should be a no contest petition. It's similar to the plea petition we had before with the adjustments that we talked about.
Judge, they just walked in with the plea petition.
Okay. My email is taking away. There it is. Do we know who admin is?
Elaine, is that the victim's family?
Hold on, I gotta turn that. That's our echo going on here.
Okay, I don't know. Can everybody hear me? I think my mic was cutting out.
No, you're fine. We hear you now, Elaine.
Okay, good. I'm not sure. Let me see. Oh, here they, yes, admin is the family. I'll
App
see
here.
if I
I
can
need
rename.
my email. To get, Mr. Liker, you sent me a new. There it is. Okay. Plea petition, correct?
Yeah, there's.
All right, so that took care of that issue. Let me get to the others. The plea petition, okay, no contest.
Yeah.
Okay, sorry to disrupt, Your Honor, and state in defense. This is the victim's family. The mom and the dad are both on Mr. and Mrs. Briggs on
Okay,
admin.
let me see if I have this plea petition up yet. There it is. All right, I'm just waiting for Word to open it up so I can look at the new terms. And we'll get started. Okay. All right, I've reviewed that. Are we ready to get started, or do we need to take anything up before I call the case?
I think we're ready, Your Honor.
Should be good.
All right, then let's be on the record in case number 2020 CR 134, captioned State of Kansas versus Gary Winters. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears by Deputy District Attorney Kayla Rayler.
May it please the court, respondent appears in person to counsel Jeffrey Liker. We both appear via Zoom in different locations.
All right, for the record, so it's clear why we're doing this and how we're doing this. We had a plea hearing set at 1 o'clock today, and we conducted that hearing. There was some, we were not able to complete the plea hearing at that time. Subsequent to that, Mr. Liker contacted us and let us know that if we were to get this done, that we believe that there was now an agreement that all parties were going to agree to. And they wanted to get it done today, specifically because we are set for jury trial Monday. And I had made it clear that the court wasn't going to be entertaining any more pleas after today's date. So with that, we hurriedly got this set up for Zoom. I shared the link with both the lawyers who were able to share it with anybody they needed to. And we are live streaming this on my YouTube channel, a practice that we undertook during the pandemic to make sure that any hearings that we had were public hearings, as are required in the state of Kansas. So I think we've met all of those requirements, and we can go forward today with our hearing. Any objection to that, state?
No, Judge, thank you for making that record.
Mr. Liker?
None.
Okay, all right. So Mr. Winters, as I said, we are set down here for a plea, and I know we had some discussion earlier today, and I need you to understand this, that you're under no obligation to do this. And if at some point during this plea, as you probably noticed from the last plea petition and this one, it will ask whether you are under duress. And duress means that there are threats or force placed upon you to induce you to enter into a plea that you otherwise would not. Now, I understand being put in circumstances where you feel like your only option is to take a plea. To me, that is not being forced into a plea in the way that you would be forced into a plea if someone were to say, we will harm your family if you do not do this, or something like that. Okay, so I think you've made a very good record, and I wanted you to be able to make the record of your complaints, frankly, about Mr. Liker and how you feel like this isn't an option that you would choose, but if it's between this and going to trial, that you're going to choose this. Does that all make sense?
Yes, sir.
And do you feel like you've had an opportunity to not only tell me, but place on the record for anybody who wants to look into this, what your concerns about going in through this plea and or to trial are?
I'm sorry, it's cold in here and I'm on blood thinners. I'm shaking right now, so I'm
No,
sorry.
no worries.
I just want to, if you can break that down to me, please.
Okay, so in other words, at the outset of our earlier hearing, while we were on the record, you were able to tell the court your concerns about the representation that you've received and how you feel like that you haven't been properly represented. Now, my understanding is that you want to do this plea and not go to trial on Monday. And the one thing I don't want you to feel like we're doing is saying, hey, you be quiet about that and you don't complain or anything like that. But once you've been able to make that record and make sure that not only I know what your position is on that, but if anyone were to look into at your request or anyone's request as to what happened here, that you were able to get on the record your feelings about your representation. Do you feel like you've had an opportunity to do that?
Yes, sir.
Okay. And with all of this today, so we don't get too far into this, are you prepared at this time, and do you desire to enter into this plea agreement?
Yes, sir.
Okay, all right. So to take up your plea, I'm going to have to ask you lots and lots of questions. If I ask you something you don't understand, I want you to tell me that so that you and I can discuss it and I can know that You understand what I'm asking and I understand what you're answering, okay?
Yes, sir.
If at any time before you answer one of my questions, you want to consult with Mr. Liker privately, you can do that. I have a way where I can, they call it a breakout room, and I can send you guys into a room where you can have a discussion and nobody else can hear it. If you need to do that before you answer one of my questions, just tell me and you guys can take all the time you need, okay?
Okay.
All right, to get started on this process, I need to have you sworn in. So if you would raise your right hand, my court reporter will swear you in.
Amanda, you're on mute.
I'm sorry. Can you hear me now?
Yes.
All right. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right, Mr. Winters, I am going to share on my screen here the plea petition that Mr. Liker sent me.
And Judge, for the record, I believe Mr. Winters has a printed out copy of that plea petition in front of him right now.
My understanding on this short notice that Mr. Liker was able to create it and get it sent over to the jail, but hasn't personally sat down with the new plea petition on this. Is that correct, Mr. Liker?
It is, Judge. He and I have been through the original plea petition, which is very similar to this one. There's obviously some adjustments that were made. But yeah, for the most part, you are accurate.
All right. So, Mr. Winters, Mr. Liker is telling me that on the old plea petition, which was a plea of guilty with some different terms, that he went over that whole plea petition with you, and now he's created this new one, which reflects the fact that the plea is no longer one of guilty, but one of no contest, and it changes some of the agreement of recommendations of the parties as to what sentence you should receive. Would you agree with that statement?
Yes.
Okay, and you have a copy of that in front of you, right? Okay, so other than the fact that it's now called no contest and that those terms have changed, everything else in this petition to enter a plea of no contest should be the same as you and Mr. Liker reviewed. So you can see that on my screen as well, right?
Yes, sir.
Okay, so it tells me here that you're 37 years of age and you went through 12 years of school. Is that correct?
Yes, sir.
All right, do you read and write English well?
Yes, sir.
All right. Now, I know that you're in custody, but I'm required to ask, are you currently under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
That I'm taking it here right now?
Are you currently under the influence of any of those things, alcohol, drugs, or prescription medicine that might affect your ability to understand what you're doing?
The only medicine that I'm up under is my blood pressure medicine and my blood thinner medicine.
Okay, those don't affect your cognitive, like you don't feel loopy or kind of unaware of what's going on around you when you take those, do you?
Not at this moment.
Okay, you feel like your mind's clear right now?
Yes, sir.
Okay, do you know what you're charged with?
Yes.
All right, and you understand, as we've talked about before, you're under no obligation to change your plea from not guilty to no contest. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial. Do you understand that?
Yes, sir.
All right. At that jury trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You would not have to prove anything yourself. Mr. Liker would assist you throughout that trial. He could cross-examine and confront all of the state's witnesses. He could challenge their evidence. He could call any witnesses that you and he wanted called. At a trial, you would be able to testify. You would have an absolute right to testify, but you'd also have an absolute right not to testify. And if you didn't take the stand, that couldn't be used against you. In other words, Ms. Rayler couldn't argue to the jury, well, you should find Mr. Winters guilty because he didn't tell you his side of the story. Do you understand all that?
Yes, sir.
All right. If you went to that trial and you were convicted of any or all of the charges, you would have a right to appeal that conviction to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. You understand that?
Yes, sir.
Let me explain a little bit about the difference between a plea of guilty and a plea of no contest. In a plea of guilty, you would be admitting at the minimum the essential facts supporting the elements of the crime to which you're pleading. That would mean that you would admit that you did the acts that constitute this crime. By pleading no contest, you are neither admitting nor denying those allegations. You are deciding not to contest them. So at the end of our conversation, if you want to go forward with this plea of no contest, I will ask the state to provide me a factual basis. And if it is sufficient to support the crime, given that you are not contesting those allegations, I will make a finding of guilt, but you will not have admitted anything as to the facts or elements of the crime. Do you understand that?
I don't understand that.
Okay, so if you were to plead guilty, you would say, I am guilty. And the state would say, this is what Mr. Winters did that makes him guilty of this crime. And you would be saying, yes, that is what I did. By pleading no contest, the state will still be making the same allegations, but you will be neither admitting nor denying them. You will just be basically staying silent and not contesting them. So if you decide to plead no contest and the state gives me a factual basis, I will not ask you if you agree that that is in fact what happened, but simply that you understand that the state thinks that they could put that evidence on. And if it is sufficient to support the crime, I will find you guilty of that crime. Does that make more sense?
Can I discuss this with my lawyer for a second, if you don't mind?
Sure, absolutely. Let me give you a breakout room here. Stop sharing. And now I got to remember how to do a breakout room. There it is.
Yes, it's been a while.
Yeah. Okay. I'm going to assign Mr. Liker and Ms. M. Morse. You're going to get an invite to go to the breakout room. I want you to click on it, and you and Mr. Liker will go to a private room.
Okay.
All right.
Judge, the parties are back.
All right. Okay. Get rid of that. All right, Mr. Winters, you've now had a chance to talk to Mr. Leiker, and we were discussing the difference between a guilty plea and a no contest plea. Was he able to explain that to you?
Yes,
Okay, so in other words, the only difference here is whether or not you admit the elements of the crime. And I just want you to understand that when you decide to do a no contest instead of a guilty, it doesn't require that you admit anything. But at the end of the day, if the state provides a sufficient factual basis, you'll be found guilty either way. You understand that?
yes, sir.
Okay, fantastic. All right. So let's see where we got to on this. I want to open your plea petition back up, and I would like to direct your attention specifically, if I can make this work, to the area that I refer to as the agreement, and I'll scroll to it here. Okay. Paragraph 13, which looks like it's the top of page 3, the agreement says it is now this, that you will plead no contest to count 1 of the first amended information in this case, which charges you with 1 count of murder in the 2nd degree intentional, which is a severity level 1 person felony. The state will dismiss the rest of the charges. The parties agree that the state will recommend a downward departure for a total sentence of no more than 386 months in the Department of Corrections, and that the defendant may request a downward departure for a sentence of no less than 354 months. Defendant understands that he will have to register as an offender under the Registration Act, and agrees to full and verifiable restitution even for dismissed counts, and that the state would be released from their agreement if you're not going to be able to fail to appear at sentencing, but if you refuse to participate in your PSI or get disciplined in the jail. Is that your understanding of the entire plea?
Yes, sir.
Has anybody yes,
Judge,
Ms.
I apologize. There just needs to be one correction through interlineation. This will be the 2nd amended information.
Okay, all right. So they already amended your charges once. I think they added felon in possession to amend it. So it won't be the first amended, it'll be the 2nd amended. All right. Okay, so I was going to ask, has anybody promised you anything other than what I just read to you to get you to plead no contest today?
No, sir.
All right. So I understand, and I think we've made a big record about the fee that you feel under the circumstances compelled to accept the plea and not go to trial. But has anybody placed force, physical force, or made threats to you to make you enter into this plea today?
No, sir.
Okay. So there are a couple of things that you need to know about sentencing. It is absolutely true that when I sentence defendants, I listen very closely to the recommendations that they give me. And I give great deference to particularly experienced lawyers on both sides as to what the sentence should be. But legally, I'm not bound by an agreement, and I can grant or deny probation, and I can sentence anywhere within the range of sentencing that is legal for the court to sentence despite any agreement. Do you understand that?
Yes, sir.
Okay. The maximum possible sentence for anybody in this, and with your expected criminal history score of A, this would apply. The very maximum sentence that anybody could get for this crime is 653 months in prison a fine of $500,000, and 36 months of post-release supervision. Do you understand that's the maximum possible penalty?
Yes, sir.
All right. And it talked about it in the plea agreement, but you do understand that given the facts of this case, that there was a firearm used in a person felony, and the fact that you have had registration requirements in the past means that you are going to be required upon your release to register as an offender within 3 days of your release from custody in the county in which you will be living, working, or attending school, and then periodically by law for the rest of your life. You understand that?
Yes.
Okay. Do you have any questions for either me or Mr. Liker about anything we talked about or anything about this plea?
With the LSIR and the PSI. So
Right.
that basically saying I can't get in no trouble in here upon my plea agreement or in prison or nothing like that.
Until, no, it's only until sentencing, right? Because once you've been sentenced, then there's no modifying your sentence based on behavior or anything like that. Now, what the plea agreement says is the state would be released from their recommendations and they would be free to argue otherwise. It does not mean that if you get administrative segregation or a ticket or anything like that, that I will ignore the plea agreement. It just means it would give the state the ability to argue for higher. You understand that?
Yes, sir.
Okay. All right. Any other questions about this plea?
No, sir.
Knowing all this, do you still want to enter your plea of no contest?
Yes, sir.
All right. Mr. Liker, do you know any legal reason why your client should not enter into this plea?
I do not.
Then, Mr. Winters, I will ask you as to the proposed second amended information in this case, charging you with murder in the second degree intentional, a severity level 1 person felony. How do you plead? Guilty, not guilty, or no contest?
No contest.
All right. Ms. Rayler, may I have a factual basis, please?
Your Honor, if this case proceeded to trial, the state would present evidence that on or about the 28th of January 2020, officers with the Kansas City, Kansas Police Department were dispatched to Pizza Hut on Rainbow Boulevard in Wyandotte County, Kansas. When they arrived, they located a delivery driver who worked for the Pizza Hut, LaRon Briggs, deceased inside from multiple gunshot wounds. The state would present evidence that 3 different caliber shell casings were collected from that scene, including surveillance video. The state would also present evidence that LaRon Briggs had a Glock 27 40 caliber firearm next to him. During a review of that video, the state would present evidence that 2 individuals entered the Pizza Hut. One individual went to the back where Mr. Briggs was and engaged in a firefight with Mr. Briggs, who was shooting back in attempt to defend his life. The state would present evidence that 3 sets of shell casings were located because the 3 individuals did fire their guns inside that Pizza Hut. The second individual who entered the Pizza Hut fired 1 shell casing or 1 bullet and was eventually struck by the fighting firearms by the bullets that Mr. Briggs and his co-defendant Tyke Barnes were exchanging. The state would present evidence that his DNA was found on the sidewalk where it is seen coming out of his leg. And the state would present evidence that officers then went and interviewed the defendant at the hospital in Missouri where he was being treated for his gunshot wound. The state would present evidence that he arrived at that hospital with Lucretia Leak Myers and Tyke Barnes. The state would present evidence that a firearm was collected from Ms. Leak Myers' vehicle and that the other firearm was located on Tyke Barnes. All of the firearms came back to the casings that were located in that Pizza Hut. The state would present evidence that the defendant's DNA was located on both of those firearms that were recovered from Ms. Leak Myers' vehicle and from Tyke Barnes. The state would present evidence that the defendant admitted to going to the Pizza Hut with Tyke Barnes and that the plan was to rob that Pizza Hut, though later he would make a statement that he was doing it under duress. The state would present evidence that during the course of this, that he informed the intent to commit the homicide of LaRon Briggs in the Pizza Hut in furtherance of their attempt to rob the Pizza Hut. And under Kansas law, because they were engaged in that inherently dangerous felony, that intent transferred to the defendant, Gary Winters. The state would present evidence that these events occurred in Wyandotte County, Kansas, and that this plea is for the benefit of bargain.
All right. Mr. Winters, did you hear what the prosecutor said?
Yes, sir.
Okay, I am not asking you whether you agree or disagree with her recitation of the state's evidence, but do you understand that if we went to trial, that's what she believes that she could put on for evidence?
Yes, sir.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis under two theories, that being that, and look, the defendant is charged with and pleading to second-degree intentional, which is a lesser, not a lesser included, but a lesser crime than what he is charged with under the state's original case, which is felony murder, an off-grid felony. So he is getting the benefit of the bargain if the facts did not fit the crime here. And so he is gaining a benefit of the bargain. However, the state is correct in that if in the furtherance of a felony murder type situation like this, one of the defendants intentionally commits an act of murder, then the other co-defendant can have, as Ms. Rayler called it, transferred intent to show that. So there is a benefit to the bargain, and there's also a legal theory that fits this. So given the state's recitation of the factual basis, the defendant's plea of no contest to those facts, I will find he is in fact guilty of the second amended information, that being murder in the second degree intentional, a severely level 1 person felony. I'm going to order a pre-sentence investigation be conducted and a report received. We'll continue sentencing pending receipt of that report. Mr. Leiker, can you get a PSI request over to probation?
I can.
Okay. All right. I do need to tell you, Mr. Winters, as a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives designed to be deadly weapons. You understand that?
Yes, sir.
All right. We will send an email to all the parties to schedule the sentencing date since my assistant is not on. Other things for our record today, Ms. Rayler.
Two things, Your Honor. Again, I believe the defendant has the plea petition in front of him. Could the court ask that he sign that plea petition and give it to the deputies so that it could be filed as part of this case?
Did they give you a pen, Mr. Winters?
Yes, I got one.
All right. If you want to go ahead and sign where it says defendant, I would appreciate that. And deputies, if somebody could, you could either get it over to Ms. Rayler or have it available for Mr. Liker's pickup.
The other thing, Your Honor, is I believe that we tentatively picked a potential sentencing date of September 11th at 10 a.m. I can initiate an email to all the parties confirming that is the date and time that we wanted to set this.
Mr. Liker, did you participate in that? Are you available at that time?
I believe Mr. Liker was not present. This was when we did Mr. Barnes's
Right.
sentencing date.
What day are we talking about?
September 11th
Was
at
that
10 a.m.
was that date, Ms. Rayler? The time you gave, was that Mr. Barnes's time or was that?
That was the time we were thinking for Mr. Winters, if Mr. Liker is available.
It's fine. It'll work.
So September 11th at 10 a.m.?
Yes.
Okay, that'll be our sentencing date. Mr. Liker, if you'll get that PSI request done. Other things for our record today.
No, Judge.
No, Judge.
We are adjourned. Thank you, everybody.
Can I talk to my attorney real quick before you go?
Yes, I'm gonna make, Mr. Liker, I'm gonna make you the administrator. So if everybody else would leave, Mr. Liker, you and Mr. Winters can stay on. You'll be private. I'm gonna stop the live broadcast and everybody else will leave. You can speak. When you're done, you'll be able to close the meeting. We're adjourned.
you.
Thank you, everyone.
Okay, what you need?
It's just, it still got us on YouTube.